the last 7 years, I would say that the improvements in the science of attribution science and the modeling that comes with that science have now created a level of certainty that is important in a court of law if you are going to evaluate whether there is a duty to act or not act, and whether that duty has been met. So in a court of law, the standard of care and the standard of evaluation that is used is typically a more likely than not in a civil context. So now that the attribution science is able to evaluate whether anthropogenic emissions are increasing the intensity of a particular event with a statistical certainty that is more likely than not, then that is now relevant for the purposes of evaluating negligence. Should there be a failure to act or an act which didn't consider attribution science, and the consequence of that act or failure to act was that there were damages. So I'm interested in this application because in a court of law, whatever you're evaluating, if someone's been damaged and they want to come and make a common law claim, they have to prove that the defendant who they're going after had a duty, that that duty was breached, that that breach of their duty, in this case would be not considering climate attribution science, was both the cause and fact, so it actually, because they didn't consider that science, there was a damage, but also the proximate cause, meaning that it was a foreseeable activity, a foreseeable consequence, and that it was something that should have been considered in the process, that the plaintiff was damaged. And the level of proof is it had to be more likely than not.